Have you, where are they're listed?
No, not my God.
Filed it?
Yes, my God. Yes, my God.
Filed it. What? What?
Where's the vehicle? It's a hearing. Hello. Petitioner is the part of requirement, my lord. After the completion of his 14 months something, my lord, and he was passed transferred again. No, my lord, not, doesn't look because of election.
So let him get instruction.
The 45 fix a lot. It's
Friday.
because of election.
Tomorrow?
Day
Get on
after tomorrow, day
instructions.
after,
Right?
day after tomorrow,
Not day after, then Friday.
and tomorrow, along.
Okay, tomorrow.
Tomorrow. Then, my lord, status quo.
Tomorrow. Let us find out why you've been transferred because of election. Election.
Does not reflect so much.
It does not reflect, therefore we have to confirm. Let it come tomorrow.
Tomorrow.
This matter tomorrow. Instructions. Again tomorrow.
Okay. The passport. Not obtain the relevant record.
You're not pressing.
What I have stated in the last statement, that record I could not obtain. So minor may
What did you state in the last state?
I stated that petitioner participated in the screening process conducted by the government to find out her genuineness of the appointment, and subsequently they put a candidate and candidate took a decision to accommodate them, those who were illegal or irregular, but they are continuing. Accordingly, the petitioner was also accommodated. That accommodation order I could not obtain.
Press the review brief.
No, man, I'm not saying that, man. But that whatever the record was there on that, I could not obtain. Whatever disposing of non-merit.
Not obtain is one thing. Whether you like to obtain is another thing.
In fact, I have communicated with the department, but no.
We are asking you whether you like to obtain. Have attempted and it is not available.
I have attempted, but no instructions received from the department.
So no instructions received, then the question would be whether you would like further time because you're filing a review and you want the disposal on merit.
There is an observation, that is why I am saying, madam. Otherwise, madam,
Where is that observation?
last week, madam. If the records as paid for are not paid for, the matter may be heard and decided finally.
Is there any earlier option for the reports?
So this is the first order, madam.
Seven two.
Yes, madam.
7/2/2017. Screening committee, ultimate categories. What are the three categories? Category, second category, working but not regularly. Working vis-a-vis the claims of such petitioners that they are still petitioners belong.
After
And past service benefits. Same. Same. Since of the undertaking given. Appointed, see subsequent appointment.
No, my submission is
After
No,
the screening
nothing,
committee.
nothing much. Because why I will opt for that? When there is a clear cut order of this honorable court that you pay the same.
No, but you are in placed under category 3.
No, nothing was there. Earlier, in the earlier brief petition matter, no ground was taken. Such ground was. I have got the matter. I want to rely on the 5 judgment of this honorable court matter, one of the Supreme Court, when review will lie.
Counsel, counsel for the review petitions. Subsequently, also passed in the applications very soon. And the contention of people submitted themselves. So this in 1992.
1992, I've got the salary up to 2007.
And
That is the tax, the steering committee, my lord. Those were earlier to the signing of the writ. Not involved in this.
still in service?
Yes, I'm retired, man.
You've retired when?
My lord,
When?
21.
17.
That is, my
Judgments.
lord.
Give us the citations.
2013 8 SCC, my lord, page 320. Party's name is, my lord, Kamlesh Verma versus Mayawati. I have got other 5 judgments, my lord. One of
Give us a list.
and I've got the judgment copy. I'll provide that.
I prefer to rely upon the scope of review is very limited. For hearing matters.
One judgment by your lordship with division bench.
Scope.
My lord, Supreme Court judgment, paragraph, my lord, 20.1.
Yeah, you've given it. We have seen it.
My lord,
We have seen it. It's given the list.
my lord. Judgment is also there. Paragraph of the Supreme Court.
Several,
He did not join money. Order was issued to her. He did not join money.
its order is not here.
Order is not here and she did not join also money.
But also submitted. That's why there is a problem.
How they can speak about the judgment of this matter? the name of
These
the
records,
second item. They have not filed counter affidavit. They have filed only affidavit manner. They have not filed counter. Till today.
I'm representing madam. Let me take it up after 2 weeks.
They have filed counter. 8 years is in, more than 8 years is in elapsed. They have not filed even counter affidavit. They have filed only, my lord, that proceeding we need. What, my lord? 5 respondents, my lord, they have filed affidavit, my lord. Two separate affidavits there, but repetition of fact, my lord. Whatever they mention in the review, my lord, those facts will be mentioned, my lord.
Filed on 12th of August. Madam.
One is 28.
Get instructions and tell us when you want to comply, otherwise we proceed.
Man, that may kindly be mentioned, my lord, observed, my lord, without doubt.
Counsel for the
April, that, my lord, 7th or 8th April.
8th April.
Fine.
He said almost more than five years, but he is not receiving the certificate. Kindly produce the last order.
Respondents, what have you done?
They have written to the development textile for granting it. I will follow it up. What?
Seeing the last order.
Yes,
Para 7.
I have received the forwarding instruction. After instruction manual on it. Right,
But if instructions don't come, they don't come. What can be done?
Can leave encashment benefit. They are releasing some portion of it, but they are not releasing whole amount.
Who is the officer required to do it?
That is respondent number 2 and 3. He is the same person. MD, managing director, and chairman. Chairman is an independent body, madam. Chairman is an elected body. Is an MLA. MD number 2. Number 2 MD.
What basis are you claiming on this?
As per section 4 of Disciplinary Act, and also
No, no. Service.
they have passed an order. I will let me kindly come to page number. Page number 12. There is a statement, the amount to be payable. Which is
How
issued
much
by
have
the,
you received?
I have received till filing of this case. 1,70,000 out of 3,58,510 rupees. And the gratuity amount whole not this.
Received how much?
Received 1,70,000 till filing of this case out of 3,58,510 rupees. And plus gratuity benefit. Not this.
What is the MD? The employee of the corporation.
Now, the joint secretary, additional secretary in employment taxation. Under an additional charge, he doesn't get any salary from. That is what my lord, he has written to the, as an MD, he has written to the director handbook. So that not only him, my lord, few others are there also. And there will be, my lord, it is not that they are not pressing, my lord. They are moving the file. My lord, let matter may come after 10 days. So that give the figure.
You can close the petition with the direction. The question is, how will you recover the amount?
Similarly situated method earlier the
Mr. Counsel, we address you as learned counsel because we expect you to be more learned. I can see, perhaps you not advise your client properly. There is better forum available for screen. The direction. How will you revive? How will you receive the amount? Come back to the court and file a contempt.
in earlier situated method the court has directed and accordingly they have paid to other petition.
Bring it on record. Why have you not brought it on record? Where are the other orders? Where are the orders passed by the corporation that in terms of the court's order, the amount is you are urging the rights of your client before the court. You crystallize these rights and base it on the parameters available. As if you are before the court waiting for legal advice to be tendered by the court. Can it be? We can't give you legal advice. What is the counsel? In terms of the last order, we can close this writ petition on the ground of non-traverse. How will you prove it? Answer.
Direct them to pay the amount.
Now we'll direct them. How will you enforce this order? In the case they're waiting for a direction from the court, and only when the direction comes, they'll release the amount. You say so, we'll pass the order straight away. Take it on record. Stated anywhere in the pleadings that
No, I have
unless an order is passed, they're not releasing your amount.
They are given a petition. After 10 days, so that my lord, it helps when the other petition are given, my lord. We are about to get this.
Like I said, we are not here to give you legal advice. I wish,
my lord.
but we cannot.
Fine.
But unfortunately, very sorry state of affairs. Man retired in 26 years, he is asking for some amount he is required to receive. Government doesn't know where the money is going to come from. Files are moving from one desk to another.
So, my lord, the position is that they do not have any money, my lord.
Are they responsible? Are the employees responsible? If yes, you say so.
I got a mail.
Let the corporation pass an order that the financial status of the corporation is because of the lack of efforts put in by the employees, therefore no claims are available. Let them pass an order. Why are you forcing retired employees to come to court?
I can come with the complete.
First of April. Based on 1st of April on a respondent. Plus, if you have any material that pursuant to orders passed by the court.
Nylon. Nylon. I have silent evidence.
Hearing.
Not proper.
What is the claim here? The entry was to any extent. Fine. Then the common promotion order. All these are before the court. Which are the petitioners? So 24G. 24G. G. Petitioner. They are admittedly senior to you.
They are senior to me.
Now, for which year?
2024.
These are vacancies arising for the year of 2024.
Fine. Seven, 48. 7, my lord.
There must be clear vacancies in the year that you are claiming for. What
Yes,
is the
vacancy-
clear vacancy?
Clear vacancy is 10 numbers.
10 numbers.
10
So out of that, how many were promoted?
7 numbers.
7 were promoted.
My lord.
So 3 vacancies remain. At least
Who says one?
some of the petitioners could have been promoted. Anticipated vacancies will be the vacancies are likely to occur because of when he will be promoted or likely to be anticipated vacancy by by the officer. Unless the vacancy or the it's clear. When So according to you, there are 6 posts available. 6 posts available. And there are 5 petitions. See what help.
Another DPC was held.
Why your cases are not considered? Satisfy the eligibility.
Yes. Estimates were promoted.
What does the rule say?
Five months. When service in the cadre of sub-divisional 5 years, or they have to render 10 years of continuous service, cadres of service on the first day of January of the year. Have 5 years of continuous service in the cadre of sub-divisional level development officer. We have completed about 10 years of service.
Stand of the government in this regard?
This says that in their affidavit, this rule was not correct. After implementing this rule in respect of our bestmates manner, by which order, by a common order, our bestmates were also promoted. They have not completed 5 years of service. Their cases have been considered. They have been promoted. In our case, they said that this rule is not correct. So, they have come up with a amendment in the year 2026, March 2026, only to take a promotion. There is a disparity, Lordship.
5 years.
Applicable the service only. Just submitted that the eligibility for the promotion of the aforesaid the service roles cannot be interpreted as a matter of allow the official to bypass a prescribed experience and either cater solely on the basis of the strength of the service of the department. The promotion structure under the state rules is designed to
You are reading from?
paragraph 6. Why this figure is there?
You need another 3 years.
Very good.
Instead of 10 years, 11 years.
Retrospective development of the incumbent shall have to render at least 10 years of continuous service in the care of assistant fishery officers. The first year of January fishery development officer and assistant fishery shall have a complete 9 months of training, fishery training.
First thing is 10 years. 10 years of continuous service. And then 9 months. This is the effect from 12 to 26.
Service to lot. Service year is being concerned that service to.
Take correction according to which code they does not appear to be take amendment. Take from 12 to
Download him.
PPC of that period is complete.
No.
Not held.
Held.
It was held.
Again, it was held also. I have not got the record also. Yeah, there is an order for the record.
Submission before the court was that pleadings are complete, matter should be fixed for hearing.
It's not
You did
there.
not say that the records would be relevant.
Record is not.
If it is relevant, why did you not make a mention in the, we would not have embarked on the hearing? Wait for fixing a date.
For hearing of that.
That is for the court to decide. But for hearing the matter, according to you, if the records are necessary, it was incumbent on you to mention before the court that the records are available, required is not available with you. Was that submission made? Then,
That was. Yeah.
get the records, we'll take it up on Thursday. Thursday. What is next week? Next Tuesday. That will be 24th. The records must reveal whether the DPC had undertaken there's some, he does not have instruction with the DPC. But subsequent find out what they have been promoted. So you're not challenging the promoter. Yes, permits, madam. Good permits. No, that is your interpretation. There can be another interpretation. I thought I will not. That is it. Fine. Is 36, 11C. 11C is 5 years in subdivisional fishery development officer. So, fishery development officer. But satisfy these 5 year requirements. Five or six officers have been brought. Why not? What happened after? You're still working. You're still working. It's not my dear mother. Regarding the development.
Six pilot, I have some instructions. Yeah. Provided to the government for FR 17. It's 13. Time to for consider to act upon the proposal till the NCC is in force. Otherwise, he has got promotion for DCF also.
Seventeen.
Subject to any exceptions specifically made in this rule and to the provision of sub rule 22, an officer shall begin to draw the pay and allowances attached to his tenure of a post with effect from the date when he assumes the duties of that post and shall cease to draw them upon as he ceases to discharge those duties, provided the comment matter and not employee who had been denied promotion due to the fault not on his part, but in given retrospect subsequently on consideration of his reputation cannot be denied the benefits of media pay. That promotion, when it was considered, it was a seal cover. Later on, he was exonerated. So when we are invoking this FR rule and granting him retrospective the benefit. says that he wants to be promoted to ACF, but that promotion was put on hold because DPC found that his promotion was kept on a seal cover. Later on, my lord, because there was a DP pending. Later on, he was exonerated from those charges and seal covers open. But till that time, he got promoted, my lord, from other posts, my lord. But that period, my lord, during which he was not promoted, he claims retrospective benefit. My lord.
Time I was SCF man. Now I got promotion on the last position. I am surprised that we have been kept. Now core issue is my lord, my retrospective effect because already there is a direction. Consequently, have a look at page 33 now. First paragraph.
You have also been promoted to the post.
For that matter, my junior was promoted. That your lordship will see. That is my case. As per junior, I am
Found to be eligible. Seal cover means there has to be some finding.
That, that is the reason, madam, we are now that invoking that rule 17. Of 16 or 13.
17 to
Since he was not given promotion at that time, 17 says, madam, the reading of 17 reveals that he will get the benefits as if he was on that service, madam, because he was
that
not
benefit cannot be restricted only.
that, madam, we are doing that in full, madam.
my lord. Can improve the work. That I have a next man.
Madam, he was exonerated from charges.
I'm talking about the DPC.
DPC, my lord,
He was seal cover. Was he found eligible?
he was found eligible, my lord. He was given promotion. Now he was ranger. First he was a ranger. His next promotion was to ACF.
Where are the findings of the DPC?
I don't have the DPC finding, but my lord, petitioners had approached this court to provide another writ petition, my lord. Pursuant to that, my lord, my lord, kindly have a look. No, no, my lord, another writ petition. Things got delayed because of that.
45.
So there is no exoneration.
But page
35. 45.
minor. Subject to the revision without sending any reason, the
Now you are
now you have just the subsequent. Now I want, my lord,
Page 36 is prayer, man. I will clear everything.
by representation.
prior to
Relax that FR. And these promotions, man, before the MCC, man. Before the prior to it. Everything is prior to it.
so you get it, you will go to better.
Public.
What additional affidavit have you filed? Item eight.
that we have to verify that pilot the 10 years back.
Last order, 3126, 3001. There is a finding that they have rendered almost 70 million.
But the thing is that for benefit of the pilot from 10 years.
Till the date of the judgment. Let them serve as extra copy, we'll get the instruction. What is your prayer before the court?
Prayer was for regulation of service. That is cannot be done.
Service? Where is your appointment order? Where is it? Can you tell?
Seventeen.
Where is it? 8617 is the date of the judgment.
Judgment. Debit 45 of 2014.
Yes. Where is your appointment order?
31.
Seen this order, Mr. Dhor?
The thing is that everything now it boils down to finance filing. The finance department
No,
ultimately.
finance will come later. See the direction.
Yes, my lord. In PRI, I have seen that.
No longer 10
But-
years up to the judgment of the vendor.
Trying to contact the finance.
my lord, in para 7 of this order, my lord, makes the discussion that such objection was raised by the respondent. And the other thing is that whether let us, my lord, the original affidavit has come, it's a new thing now. That was not their claim in the original writ petition. Now they have come because the direction is honorable from the last submission, they have filed this. My lord, let them serve as a copy, will take instructions from the pardon bank. But if you go by para 8 of this, submission that if when the somebody is getting 10 years, why not other? So why he can't go beyond?
Let's expand the scope of any seven. Similarly situated.
I'm still voting in the
Abandoning the claim for argument. Passed by coordinate bench. 5/10/2023 passed in WPC 7131 of 20. Rendered by section bench of this court in open thus, namely writ appeal 45 of 2000. See number. Be of an order passed by coordinate bench rendered in
Next document. Petition. Now, after I've just placed one letter issued by the circle officer dated 27th of February 2026. As he had expressed the inability to issue the NOC, because already an NOC was issued by the Norway DCF in favor of the private respondent number 10. Now he is stating that as per the government notification dated paragraph number sec 2,
Let him bring it on affidavit. These kind of explanations on letters will not go. Ask him to file an affidavit why you can't do it.
That is what I'm saying. Actually, a clarification also, so I need to get a clarification because as page note.
So we are trying to understand the direction in para 5.
Para 5.
Read para 5. What is it?
Taking into account this code directs the respond number 9 to provide the next of kin to JK Goswami to represent the respond number 9 in the instant proceedings and same next of kin.
Some next of kin certificate was issued. Where is it? No, in the writ petition, is it there or not?
No.
It is not there.
Filed by private respondent is there.
Where is it? Who represents private respondent?
My lord. There's a kindly see page 41, my lord. 41.
In the directions of the court has directed the respondent 9 to provide a copy.
Yes, my lord.
Respondent 9 is circle officer what? Nobody. Gologan. How can you provide a certificate next of kin certificate from Norway?
Alia is my lord. Kindly see page 41, my lord.
Now, who has stated before the court that another next of kin certificate?
Kindly see page 41. Page 41. Tension matter, my lord. Which was issued by
Commandant.
thereafter, my lord, is written by best NOK certificate. First line.
Why direction to respond 9?
That is, I am coming. At page 12, 42, my lord. Commandant returned to the deputy court of best NOK certificate. Then, my lord, write to Cycle Officer Golokwan. Submit an inquiry report. Then Golokwan Cycle Officer submit a report, my lord. 45. Thereafter, my lord, sub-division officer, my lord, after hearing both the parties, petitioner as well as respondent number 10, fast and speaking order, my lord.
Where is it?
Page 52, my lord. Last para, after the result of the party.
is Asalota
Petition.
petition. Finding
Yes, ma'am. Then, my lord, thereafter, the another certificate was not issued. Next petition come to the Passport order taking the restaurant number 90. And the certificate, pension is pending since 2014. Now the
now what will happen to the NOK issued by nobody?
speaking order, speaking
Yes,
order.
or otherwise.
Right. At the last paragraph, Your Lordship, as per government notification dated 23rd September 2020, provides that an applicant can apply for the next of kin certificate to the circle officer within post that deceased decided prior to his death. Since the address of the deceased as reflected in the death certificate does not fall under the this office is not competent to issue the NOC certificate. Petition was furnished prior to his death. However, he failed to complete any paragraph number last paragraph during hearing before the addition district judge agree wherein certain observations were made. On that basis only, the 52 order was passed by the subdivision magistrate to issue the next of kin certificate.
Specific direction that it has to be issued by the circle.
Parties were
By
government what for my certificate from the Dhubri member. That is I am effort member 42. Amendment written letter to the district. Time of date my service member. Service
what documents did you fund?
like in the service book at page number 52, it says it was observed. In the one second, not 52, sixth paragraph. Accordingly, both parties appeared before the sub-division magistrate, and the second party, Zonaki Adhikari, private response number 10, has produced relevant documents of the relationship with the deceased, late Kamalakanta Adhikari. Zonaki Adhikari produced service book of late Kamalakanta Adhikari and proof of identity and residence of her children, wherein late Kamalakanta Adhikari's name was mentioned as the husband and father. Department, district commandant.
Who is for the commandant?
The death certificate at page number 32 says the address as well. Test number 10.
And what is the petitioner's name?
What my lord, at the time of death, my lord, husband of the petitioner was interviewed with my lord.
How did you get a copy of the service book, Mr. Department provided you? Fifth paragraph.
Right now, I have no. Earlier, my lord,
What documents have you produced? What evidence have you? Where is that? Where is it?
45. As the circle officer is not aware of the 52 order. Order is very clear because both the parties represent.
In his communication addressed to Governor Gupta,
Ask-
Then he abandoned it.
Last, your lordship, second last paragraph, it is also pertinent to mention that a letter was received from the district commissioner brief, dated
You are
16,
reading from?
this instruction, page 2. Second last paragraph, your
Yes.
lordship. It is also pertinent to mention that letter was received from the district commissioner regarding inquiry into the next of kin of deceased Sri Kamalakanta Adhikari. Accordingly, a field verification was conducted by the concerned LRA. Upon verification of documents of the petitioner, Srimati Asalata Adhikari and her daughter, Srimati Shekhali Adhikari, it was clarified that they are legal heirs of the deceased Sri Kamalakanta Adhikari. Next line, Your Worship. It was also confirmed that during the inquiry that the deceased had a second wife and 3 children from the second wife. However, this office could not collect the documents as they reside outside the jurisdiction of the undersigned. Accordingly, this office submitted an inquiry report dated 28/9/23. This is for There's another certificate.
This is not. So, you can know. You know, fast forward.
Point of loss order. Fine. Was an inquiry in regard to the permanent resident of the petition. The report
Why
here,
is it not mediation?
I still made the job.
Party?
That report has not been.
no, that report I have with me. If lawsuit permits, I will file an affidavit. Thing is that lawsuit once upon a time he was a resident. After this he got married. And then after with her husband, she stayed, she went on staying with in some other place. by the Assistant Commissioner Tamulpur,
Assistant.
Commissioner Tamulpur, under the office of District Tamulpur.
Okay.
Name of the company now, the application box. Name that. Filing is What's it?
This one.
Dismissal order, Lordship. Subsequently, the petitioner has been appointed with a fresh appointment letter, Lordship. This has not been challenged, and there are earlier rectification also where everything has been observed, Lordship. We have brought this on record for our affidavit, Lord.
This again after one.
Lordship, this is
Karbi Angle. Karbi Angle.
Lordship, it is something different, Lordship. This is a appointment where on compassionate ground, Lordship. The DLC recommended, with the DLC recommendation, they appointed, Lordship, without taking concurrence from the Finance Department and the SLC, Lordship. That's why after 4 months, the salary has been stopped. So there are other petitions also. I can't provide the numbers right now, Lordship, but the similar cases are also pending before the
There
Supreme
is an SLC requirement.
Court. Areas, Lordship.
Yes, and finance department.
I'm appealing for the hill area.
No, going asking you, going up.
That is what-
Requirement. See who say.
Third. Yes, Lordship, it is there. 7, Lordship.
I have filed the amended. Second step, they have made the
Order is only to amend. Fine.
Lordship, hilarious department, I am appearing from.
Again. Report. Right.
Paragraph 8 of order dated 2. I program of the same registry, a copy of the
Final interpretation. I notice.
Lordship, I shall inform Lordship में
Any transfer subject. But it's
Idea we have appointed by the government.
appointment, power of appointment.
Lordship.
Here before the authority.
And 17. I have received yesterday, but that's not properly done.
The matter where
Yes, my lord.
state.
Not reinstated, my lord. We have
Dismissed.
dismissed, my lord.
Then you tell him,
Yes, my lord.
we'll set aside.
No, not.
Still. Back with you.
That is coming in supply. I was filed, my lord. One was, one of,
That fighting that petrol pump.
yes.
Yes.
One of the Lordship,
One against one, there is no criminal proceeding.
yes, my lord, yes. Yesterday I received, my lord, but not so, my lord, Lordship allowed some time. 20,
You are representing client, you are dismissed from service.
2014, my lord. It's up to him. My lord,
When
on 24th, my lord, we after, my lord. Yes, my lord.
Service.
Yes, my lord. And then, my lord, if, my,
First of April.
my lord,
First of April.
first of April.
This from first of April. Or let us have second of April, the hearing date. Exhibited, where proof or only exhibited.
May April, my lord, 7th of April, my lord. Yes, my lord. Then, my lord, the 26th of March also, my lord, no problem, my lord, 26th March. Okay. Yes.
Sections were called for.
One hand move and
Medical.
right.
As of now, the cause of action doesn't say. That is the immediate one. Start it.
Have it.
Very much.
It might have been on all the records that the liabilities of the company, my lord, which
But
they have
these
not disclosed in the share purchase agreement, my lord.
So, but you have to raise the dispute. First, you have to confront them. Confront them to say that please cancel this agreement. Does not stand in view of the suppression of the right.
Now should we come to some of the
Or that the conditions and clauses in the share transfer agreement are not everything. Certain disadvantage for the respondents in view of the suppression. They are in dispute to the extent.
if the documents speak itself, my lord. The
It's
additional,
just there, but dispute has to be raised by you. Say, let us say both parties are exchanging documents after documents, but the matter is not before the court. What will parameter be?
but the amendment of that,
Unless you can point out that this suppression will father or satisfy us only file before the NCLT.
lordship, that is not my case, my lord. If they would have filed and I would have gone to arbitration, then that would have been my case.
But what are you here for living seals? Why do you want an arbitration?
There are lots of number of disputes, my lord.
Where have you raised the dispute?
The document itself shows, my lord, that there is number of disputes, my lord.
In your notice, show us from your notice, have you stated anything?
Notice,
That
my lord,
because of this agreement falls through. What is the not applicable? Or you're not entitled to make payments or you are entitled to receive more payments. Kesari, what has happened to your NCLT petition? Why is it pending for disposal for so long?
Your Lordship.
You are aggrieved by operation mismanagement.
Yes, Your Lordship.
When was it filed?
2023.
Then we are in 2026.
Yes, Your Lord. Actually,
Why are you allowing the petition to be pending there if you are really aggrieved by operation and mismanagement of the company?
Your Lordship, we have mentioned several times, and other sides were also mentioned because
You're an
not.
astute lawyer. You're an astute lawyer. You know what?
If your Lordship can give direction, that I'll be very pleased, Your Lordship, to dispose of this petition within 2 months or 3 months. Your Lordship has the jurisdiction, Your Lordship.
NCLT.
Yes, Your Lordship.
How can
At
I
least
have the jurisdiction when you file it before Kolkata?
we have mentioned several times, Your Lordship.
You must appreciate the comments coming from the court and not go overboard. How can we decide a matter pending before NCLT Kolkata?
Mostly because, Your Lordship, they are mostly taking insolvency matters. After several mentioning as well, they are giving priority to
Mention it before the principal seat in Delhi and get it transferred to NCLT Gauhati.
Yeah, that is the more convenient way.
That is for you to decide, not for us
Yes,
to suggest.
Yes, Your Lord.
Or even advise.
Because the
Roy,
act provides need to be disposed of within 270 days.
There should be, what is the dispute to refer to?
Yes, Lordship may come to my paragraph, my Lord, in the petition itself, my Lord. That notice, my Lord,
You see the notice, you see the judgments pertaining to 21. Have to prima facie lay out what is your grievance, for which they have to concur on your finding. What is your notice again?
page 120.
120.
Lordship is giving the notice.
First paragraph, you say you have raised the dispute. In terms of the share purchasing.
My property portion of the letter, my Lord. That filing
You show us from the petition filed before NCLT that but a dispute raised respect of their purchase. Title filed under operation and
operation and mismanagement plus, my Lord, they had also to rectify the company's
registered.
then 213, the order of investigation into company's affairs, then relief against mismanagement and prejudicial
So
conduct.
essentially everything flowing from operation and mismanagement.
I'll go to the company petition matter. Lordship will take up tomorrow, my Lord.
Day after we can attend.
Day after.
Your Lordship, allow me the liberty to appear virtually, Your Lordship, day after tomorrow.
You have all liberty to appear. You have the query raised by the court as to whether dispute actually arises. respondents are saying to respond. In the matter. We'd like to come back to the court and raise for a date.
Oblige, your lordship.
April any date.
Counsel, though the petitioner prays for promulgation, submits that matter we take it up for the.
Guideline.
There is no guideline. If my lord, you have submitted convenience note. Yes. Alright. Come to convenience number. CBC, yes, my lord. I'll just draw my lord's attention. Page 56, my lord. Uh,
Six.
not permits, I just beg to submit the facts of the case.
We wanted to see this guideline even there.
Acha.
Because you are referring to guideline,
Yes,
some violation of the guideline.
the CBC guideline that speaks of the period under which
That's why we wanted to see
Yes.
it in here. There was an allegation against that some payments were made in respect of some casual labor.
no, my lord, it's not the issue. So this casual fit or laborers was by one in the target area. Got 179 days. And the recruitment was done by one task force known as 760. What are the task? I am the deploying authority of the casual. The payment of the casual paid laborer passed by my 760 task force and their audit officer. I have no. For the period starting from 21st July 2020, 20th like 20th August 2020, of payment by the ICICI Bank had a random check at the time.
Right.
I am the deploying authority. Before release, because payment has been passed by the auditor, recruitment is done by the 762 PRTF minor. Deployment is done by me as a preventive measure because the payment at a random check. Found that name and father's name of 18 casual paid laborers are matching with the names and father names of another set of 18 casual paid laborers who are working in other units away from 100 to 100 kilometers. Then we instructed them not the pay. As per the instruction of the government of India, whether the state amount amounting to 5,50,000 approximately was deposited into the fund. The background of it. But basically, investigate the issue because that period was COVID period. There is a shortage of laborer. Laborer was recruited by the higher authority. Payment was done by the audit authority. Wages are released by the ICICI.
Your role is
Deployment. I do deploy the labor. And just told the ICICI bank not to release the payment and the said amount reference to the guideline before this public fund account as per the guideline. I draw my lord's attention what he said to various. But what happened? With reference to my lord, this this is the army-centric organization. This is the army-centric organization. So what happened? They do not prefer the preliminary investigation, unlike the civil department. If there is any no prima facie evidence, they do the preliminary investigation. Here, they resorted to Army Act 177 by deal with Army Rule 1. So, my lord, the first court of inquiry was held. That is on the first court of inquiry was held, my lord, 24/11/20. I draw my lord's attention to the court of inquiry, the lacuna in the court of inquiry. Then, my lord, because delay for that will, my lord, delay. Then, my lord, what happened? February 22.
When was the issue? The episode is of 2021.
Yes, my lord. I'll draw my law's attention to the convening order of first court of inquiry that
The allegation against you pertains to some episode.
this is the episode
For
that
pertaining to
why
which year?
this
Pertaining
is
to which year?
basically a suspicion to substitute the legal proof. And my case is the case of no evidence.
What is the allegation against you?
My allegation is now, my allegation is that why I have not, because subsequently there is agitation. Those people who work during that period, they claim their wages. We told them, told the bank not to release till they re-verification was done. Meaning re-verification.
What is the allegation against you?
Allegation. Yes, my lord. Let me let me draw my law's attention to the memorandum of charge. That is memorandum of charges page. Page 31 of my writ petition number 486124. I read, my lord, that the said Randhir Kumar, J Civil, GS number 1784339A, now A Civil, GO number 5668, presently posted at HP East, that is Lancashire, my lord, while posted with 55 R6762 PRK, border road, top Vijay, that is in Kargil, my lord. During the period from 4th August 19 to 15 November 21, and deployed in gate in charge of gate Pukar and Tapi, was responsible for mastering of CPN and also disbursements of their wages deployed at gate Pukar and Tapi at master roll number 1016 and 10151 for the month of August 20 period 21st July 20, 28th August 20. I submitted the period 21st July 20 to 28th August 20. Now I am in 26th. Additionally, he faltered, allowing incomplete and incorrect documentation while preparing medical sheet. I submit, my lord, I'll prove to my evidence that medical sheet is prepared by medical officer, Captain Officer, that falter. So the charge sheet itself says that they have not alleged to have committed a mistake or crime. He himself has faltered this. By authentication of particulars pertaining to CPL Aadhaar was blurry. They say the allegation is that Aadhaar card which was based upon was blurry. I will show, my lord, the blurry Aadhaar card was not incorporated as a documentary evidence in the memorandum of charges.
Now, what happened to the inquiry?
Well, I understand. On the past, because I came before my lord, there is a law laid down that if I am aggrieved because of the vitiated, uncertain, indefinite memorandum of charges, I can block the road of the writ court. Even after attending the inquiry or before after attending, there is law laid down by Honorable Supreme Court. Why not in the three cases?
So you have come at the threshold at the time when the
Yes, madam. I got my first stay order on 20th 11/24 in this writ petition, and my lord, another writ petition which has come from Janagar Bay. Here I got an elaborate stay order on 4th April 2025. My lordship, That I have incorporated, my lord. I have incorporated the shift 4th April 20.
And
That I have
the order
incorporated the
is
rejoinder.
something-
4th April 2025.
But here in this matter, there is an interim order.
In this matter, there is an interim order.
There was an interim order.
This order.
My lord, I beg to submit, my lord. The Union of India filed an IA for the vacation of the interim order, which was not considered. I filed a counter, which was not considered. I was not present, my associate was present and indisposed, and the coordinated bench was not happy, so they vacated the order. Even, my lord, on 5th of February, when learned Payne just submitted before the Honorable Court that no disciplinary proceeding to be initiated. The utter surprise of my lord, they have issued the summons to the client for appearance before the inquiry officer, even in spite of the submission of my learned friend.
But there is no interim order. Has held that not extending.
My lord, yes, my lord, that is not my case. My case is that I am aggrieved. I am aggrieved because of the following reason. Number one, my lord, they choose in the counter filed in the board 3 writ petition. They have commented the Union of India that based on the recommendation of the Court of Inquiry, they started further investigation of the issue of memorandum and further onward process.
Why don't you take up these grounds with the inquiry officer?
No, I can't.
Why?
Well, I can't because when I am aggrieved because of the Court of Inquiry, where I have not given the opportunity to 180 Army Rule 180, my lord, but the Supreme Court has laid down the law. He should be the charge official should be present throughout. He should be given a chance to cross-examine the witnesses present throughout. And
What is the basis of the charge?
basis of charge number, as I have read, my lord, this now Court of Inquiry. Then I have to draw my lord's attention whether the charge memo is consistent with the terms of reference of the Court of Inquiry, where they have laid down that one
Is there any rule that prescribes that prior to issuing a charge must be court of inquiry held?
yes, 180, Army Rule 180, my lord, I read.
180. So governed by Army.
Ah,
Army
yes.
Act rules.
Yes, my lord. Army Rule and Army Act.
And that being a court martial.
I read, my lord.
Army Act rules.
Yes. And before that, 177, because the Army Rule 177 says that the Court of Inquiry is an assembly of the officer, the junior commission officer, or of officer and junior commission officer, warrant officer or non-commissioned officer, directed to collect evidence and is to examine to report in regard to any matter which may be referred to statement. So, with reference to the Army Rule 177, they convene a court of. It is in their amendment in the counter. And then, my lord, 180.
They are governed by the Army Act and
Yes, my lord.
scope for the government of India.
My lord.
Charges.
Yes, my lord. Now, this is there are now certain exceptions are there for the border of organization. And that exception has been laid down in statutory routine order 29 and 30. That except, but this, because some exception, because one cannot be reduced in rank with reference to army. So the government has empowered that yes, after conducting the army court of inquiry, it can switch. And that has been decided, my lord, that in the Supreme Court judgment also. And this why I am subjected to army.
Therefore,
This is my lord statutory routine order, my lord.
this is the sequel question following.
Yes.
This would be that is the removal charges based on court of inquiry.
Yes, my lord, let us come to the counter affidavit, my lord, of the past, that is the petition 4861.
Because
Read from the
let
counter.
us read from the memo charges. Is it evident from memo charges that is based on the court of inquiry?
It's a recommendation of the court of, my lord, my lord, I have to draw, I beg my lord's attention to the counter, my lord, who are the Union of India and Hamad. My lord, page 63 of my, the counter affidavit of the petition number 4861 of 24.
4861, yes.
Yes, my lord, space 63. Roman 3, I read, my lord. Keeping in view the discrepancy brought out in the vigilance check, court of inquiry was ordered by headquarter convening order number 6032A Vijay 5581 RCC DGPR 25 dated 24/11/20, my lord. My lord may note down the date, the inordinate delay with reference to CBC guidelines. And convening order for additional court of inquiry. I'll submit why additional court of inquiry was also held, my lord. Number dated 12/7/22. That is after the lapse of 2 years. There is an additional court of inquiry for a cause of action of 2021 July, 20th August, my lord. To find out the exact facts, lapses, irregularities, and identity the official responsible for the same. Involvement of officials, including petitioners, were prima facie established in the court of inquiry, oblique preliminary inquiry. They are just misleading by writing the word preliminary inquiry. I'll show my lord's attention to the convening order. And final recommendation of order for initiating disciplinary proceeding. This is very vital. So, the genesis of the disciplinary proceeding comes from the recommendation of the court of inquiry. So, my lord now have to have a look of the convening order of the court of inquiry, whether it is whether it is followed with reference to the Army 180, whether it has the support of an act, what is the requirement of additional court of inquiry, why there is a first recommendation in 2022.
What happened to the first court of inquiry finding?
Finding, yes, my lord. The first court of inquiry finding. First 10/22, my lord. And my lord will be taken aback with the how the both the recommendation is very very differentiating in nature, violating the law of equity, my lord. This is, my lord, I read from the affidavit in reply of my rejoinder that page 137, my lord. Annexure E. 37, my lord. My lord, I read everything or on the salient part of it? My lord, this is I read from the, they have, I read from the very beginning. On perusal of proceedings and various documents, conveyed I partially agree with the finding of court of inquiry concerned with headquarter DGPR convening order number dated 24th November 20. This is the first court of inquiry. My lord can note down the date. On perusal of proceedings and various documents, held on record lapses, irregularities, shortcoming as per a subsequent paras have been observed on the part of the various officials of 55 RCC and 81 RCC under Project Vijay. Court of Inquiry convened to investigate the allegation of irregularity in mastering, employment, and remuneration of CPL by various RCC of Project Vijay. Various RCC of Project Vijay was observed several laxity and irregularity. What is the several laxity and several irregularities, that is not pinpointed on the part of the executive. The entire process of recruitment and employment of CPL in the era of Project Vijay as on the instant case is heavily dependent on the activities of the maid. Well, maids is the head of those casual paid labor. Well, I beg to submit, neither the statement of the maids have been taken in the court of inquiry, nor the maids have been shown as a oral witness in the memorandum of charges. I'll show accordingly the various lapses, uncertainties, and indefinite application, both in the court of inquiry and the memorandum of charges. So here, the very stress is that the entire process of recruitment and employment of CPL of Vijay as in the instruct is heavily dependent on the activities of maid. Second one, the role, responsibility, and remuneration of the maids needs to be reviewed. So now, the recommending authority pinpointing the role and activities of the maids. So they become a focal point. Number B, there is a likelihood of forgery of documents having been carried out to the recruit CPL who have been bought to work by the respective maids. I did maids, my lord, who is the boss of the casual paid labor. Likelihood of forgery of documents. Well, what type of documents? That need to be spelled out either in the court of inquiry or in the memorandum of charges. That need to be attached either in the court of inquiry or in the memorandum of charges. Now, my lord, a large number of recruitment documents in both 55 and 81 RCC have Aadhaar card copies which appear to be forged. What is large number of recruitment documents? What are the recruitment documents, my lord? It suffered from vagueness. Now, in Aadhaar card copies which appear to be forged due to similar photograph in Aadhaar card copy as a result of medical documents. My lord, as I have submitted, the names and father's name is matching in 18 casual paid labor. They say Aadhaar card is not clear, blurry, but they neither produce those Aadhaar cards in the court of inquiry, which has got the mandates of the law, nor they produce in the memorandum of charges. My lord can kindly note it down. One is the role of the maids, documentary evidence, Gladi Aadhaar cards. Now, my lord, I come to the point C. Approximately 40% of CPL of 55 RCC and 60% of CPL of 81 RCC were paid to ICICI Bank direct paid card. ICICI Bank direct paid card, and not through their bank accounts in violation of existing accounts. Well, they say it is paid to ICICI Bank paid debit card. No KYC check was done by the bank for these cards, and the cards were issued in part to the by the ICICI Bank. Well, who will check the KYC? I myself or ICICI Bank? If there is a fault of the bank official, they should have been called in the court of inquiry, or they should have been shown as the witnesses of in the memorandum of charges. Next, no bank reconciliation statement was prepared for this account. Bank reconciliation statement, we know when there is a difference between the cash book and passbook. The bank. Now, who will prepare the bank reconciliation statement? The personnel working on the ground in the far-flung border areas, or the bank official? Now, my humble submission, my lord. These are arguments you are required to make. No, my lord. No, my lord. I am
purely on the question of law, legal principle before my lord. First legal principle is that, my lord, there is a mandates of law not followed in while conducting the yes, how yes, my lord. When I am on the recommendation, my lord have a do how the recommendation, second recommendation departed. Yes, my lord.
Resulted in violation of
Yes, my lord.
natural justice.
My lord, I have to submit for it. My lord, this
You
my
have to
legal
show us,
principle.
you have to show us, number one. Still not permissible.
I'll show the citation also.
Last not the least.
No, my lord. That is not the stage. I have come to the stage for that. Because when I'm
And
aggrieved,
coupled with the fact that the order was not,
my lord, that is,
you did not file an appeal order.
my lord, that interim, because my case was in the final hearing on 5th of February, my learned friend has committed before this honorable court that no discipline proceeding is initiated. Why I should linger on the proceedings, my lord? Fourth of April order, my lord, I just, I submit the 4th of April interim order of Itanagar bench, my lord. 4th of April order. Of Honorable Justice K.R. Surana, my lord. That is, yes, my lord, I'll show that one. My lord, that is in page 180, 186.
Just a minute.
Just a minute. This, I filed the counter in writ petition number 5792 of the 25. In that counter, my lord, I draw my lord's attention to page 181. My lord. One 81. My lord. That is the writ petition 5792 of the 20. Aman Kumar versus Indian Appeal.
579.
90.
579.
5792 of the 25. The new number given by this, because it was in Itanagar. Yes, page number 181. May I read, my lord?
That was to find
From I have filed the counter of this they are rejoinder from my rejoinder.
Rejoinder.
Yes. An affidavit in reply, my lord. Sorry, I beg my lord pardon. Affidavit in reply. No rejoinder file. Our rejoinder in the Aman Kumar. 579. Item 30, my lord.
if we have it, but we are unable to locate your rejoinder.
Yes. I can share the copy.
You can share, but we'll also have to trace out what happened to the affidavit that you may have filed. The affidavit in opposition is there. You have filed it.
Yes.
You have the dates.
Yes.
Very well.
180.
You have to read the paragraph. We have a copy of this order. Paragraph 12.
Fast, please. My learned friend says there is no interim order of return.
Because firstly it came up for honoring this matter.
Stayed.
This is a subsequent order of by the court, but in view of the order vacating the stay, I don't think that
Stayed. My lord,
In four, 482 it is state.
Yes, my lord.
5792 it is state.
Yes, my lord. And that Itanagar bench stayed, and here the first petition, Randhir Kumar was stayed in 28/11/24, my lord. Now, my lord, latest, as I have submitted the common proceeding,
How many proceedings are there?
there are 3 cases, my lord.
3 cases.
There are 3 cases, my lord.
So
There
only,
are 5 petitions.
only in one case the proceeding stay has not been.
But that Honorable Justice Coordinate Bench has stated it needs further deliberation because paucity of time. But not recently, my lord, Srinagar bench also in number 1 cases where against the law of equity, the number 1 petitioner was picked up for a minor penalty, stayed the proceeding. I have submitted the order against the memorandum. We challenge the memorandum.
Now,
My lord, now my lord wanted to know the CBC guideline.
yes.
I apologize, I could not produce at the time, my lord. This is in the petition number 19/25, page number 55, annexure 7,
That is 19.
/25, what is
WPC 19.
item 29, my lord. Page 55, annexure 7.
Page number 50.
55, annexure 7. My lord, this I straight away come to the number 3 of their guidelines, conducting investigation and submission of report. Page number 55, my lord.
Yes.
3 months time is given. Now, my lord, attention is drawn to column 7 of page number 56.
Yes.
Issue of charge sheet, 1 month from the date of receipt of the commission advice. So entirely 4 months is given, my lord. My lord, this case, what happened, my lord, this when when they started the inquiry in 2021 November. First recommendation was given 21 February. Then re-inquiry was done in the 22, my lord, additional inquiry. And final recommendation was given in 23, my lord. And what happened, my lord, before I draw my lord's attention to the court of inquiry, my lord, this in the first, because the court of inquiry has diverted from the main issue, my lord. My charge sheet is entirely based on different phenomena. And court of inquiry is entirely on different phenomena. And recommendation, my lord, what happened based on the pick and choose policy. In the second recommendation, my commander, who is the 62 BRTF commander, he has been given a simple warning. And Achilles Nair, who was the medical officer and who medically examined the 18 casual paid laborer, was exonerated in second inquiry. In the first inquiry recommendation, they were blamed on. So, my lord, my legal principle, what I am relying on, my lord, the mandates of 180 has not been followed. If my lord have a look of any inquiry, my lord, the convening order, I draw my lord's attention to the convening order. They themselves are also following that, yes, it is the mandates of 180 to be followed. In the convening order, my lord, this it is stated, my lord. I draw my lord's attention in the writ petition 4861, first writ petition of this headquarter of this principal bench, where I got a stay on 20th/11/24. My lord, this page 20, just for a moment. I'll take a short time. Para 8. First state petition, my lord, Sandeep
Don't say-
Kumar versus
Huh?
item 28, my lord, 4861. Item 28, my lord. Para 8, my lord, page 20. May I read, my lord? Attention of presiding officer and members is drawn to the following provision of Army Act and Army Rule 180, and the court will invoke the provision of the same wherever applicable. My lord, A, Army Rule 179, Army Rule 180. I read the Army Rule 180, my lord. 180 says the man should be present throughout. He should have a chance for deposition. He should have a chance to cross-examine. He should have a chance to get the finding of the court of inquiry, my lord. Nothing has happened.
In this writ petition.
Yes,
your-
my lord.
your- your
My lord,
very-
I draw my for a moment. I draw.
Mr. Counsel, listen to the very report in this writ petition. There are prayers, side of the memo,
Yes, my lord.
right?
Yes.
Now, there is the statement
Appreciated.
initiated, what are the grounds for that?
Yes, my lord. Para 10, my lord. Page 9 of the same writ petition.
Yes, para 10.
Page 9, my lord. I read, my lord. Roman 1.
Yes.
No specific violation of any established policy, guideline, procedure has been made.
Vagueness. Vagueness.
It's
Vagueness
okay.
of the charges.
Yes,
Charges
my-
are vague.
I'll come down slowly, my lord. And no specific charges, no specific violation of any established policy, guidelines, procedure has been mentioned in the memorandum of charges, and also several laxity, irregularity words are mentioned in the memorandum of charges. Read with the recommendation. I have read the recommendation also. Look, Roman,
That's what we are trying to understand. See, all the one, that the charges are vague. They suffer
vagueness,
from non-joinder of the
uncertainties,
witnesses,
indefinite,
indefinite,
and lack of material.
lack of material. Now, where do you say that these the memo charges which have been used against you
Let us
on
come
the-
to the memo of charges, my lord.
was on the recommendation of this court of inquiry,
Yes,
and
yeah,
unless,
yes.
unless court of inquiry satisfies all the rigors, the authorities cannot are precluded from
My lord, it is,
proceeding.
it is their own assignment, my lord. I did. I can read again, my lord.
Please read
Counter
again.
affidavit.
Please read again.
Again, yes. Counter affidavit. Page 63, my lord. Keeping in view the discrepancy brought out in the vigilance case, court of inquiry was ordered by the HQ DGPR convening order number 60302 A Visual 5581 R6 DGPR 25 vigilance dated 24/11/20. That is the date of past.
So,
And my lord, that's the involvement of the
according to this court of inquiry held in gentleman 180.
yes, my lord.
Right? Now, the authority to prove that if the 180
I can read the judgment.
yes,
My lord permits.
yes, please.
Already have this is the set of judgment.
Yes.
In seriatim, I'll read for my lord's convenience.
Have bunch of
My lord, this is today's morning. I have for my lord's convenience. And in seriatim, I am just ready. Where starting from the vitiation of the charge. Lord, this is very recent judgment, my lord, the first one.
Yes.
Maharana Pratap Singh versus State of Bihar, decided by Justice Dipankar Datta, my lord, on 23rd April 25. He says, it is stated, my lord, if the charge is vague, para 27, 35, and 42 is important. That's it. if it says, if evidence is unfavorable, charge sheet is vague, indefinite, not specific, and lacking material, it is vitiated. Mere suspicion cannot be a substitute of legal. Now, my lord, now next judgment. This is mere suspicion. We are proceeding, my lord. Reputation, protection of reputational right is my fundamental right. Page 27. May I read, my lord? Para 27.
What are the issues involved here?
Yeah, in the same issue, my lord. This charge sheet has been squashed.
Is it pursuant to a court of inquiry?
But pursuant to the court of inquiry, that is, they say this is charge sheet can be issued either with reference to preliminary investigation or with reference to the court of inquiry. So they choose not to hold preliminary investigation, but to hold court of inquiry. The moment court of
This is the finding of the apex court in the judgment.
yeah, that is another judgment. I'll consider it and I'll read, my lord. Initially, I'm reading the vicious.
We are asking you a question. Not in the
I read the judgment from Honorable Supreme Court of Union of India versus Sanjay Jethi. This is exclusively with reference to one. There are a lot of
is
judgments,
it a part of the bunch?
but not this bunch, earlier bunch I have submitted.
Earlier part.
Earlier bunch I have submitted, my lord. I've got it. My lord,
Sanjay
Union of
Jethi.
India versus Sanjay Jethi.
Yes.
It was decided on October 18, 2013, my lord.
Yes.
Para 5, I draw my lord's attention. Para 53, my lord. Para 53. I read, my lord. In a court of inquiry, participation of a delinquent officer whose character or military reputation is likely to be affected is a categorical imperative. The participation has to be meaningful, effective, and he has to be afforded adequate opportunity. It needs no special emphasis to state that Rule 180 is framed under Army Act and it has a statutory color and flavor. It has the binding effect on court of inquiry. The rule provides for procedural safeguard, regard being had to the fact that a person whose character and military reputation is likely to be affected is in a position to offer his explanation, and in an ultimate eventuate may not be required to face disciplinary action. This is very important because if I can prove that I am innocent in the court of inquiry, then further consequential action should not be taken.
What are the facts?
Well, this the facts involved. Well, this is the law framed by the Supreme Court in this analogy, well, the fact that the full opportunity was not given in the participant in the court of inquiry, and this. The one colonel was involved. There is some alleged alleged misconduct, my lord, in hiring of transportation for the supply of ordnance factory. Supply of ordnance. But subsequently state, thus understood the language employed in Army Rule 180 postulate of a fair, just and reasonable delineation. The duty of authority to ensure that there is a proper notice to the person concerned and he is given an opportunity to cross-examine the witnesses. And most importantly, nothing should take place behind his back. It is one thing to say that court of inquiry may not always be essential or sent to a non for initiation of court martial, but another spectrum is that once the authority has exercised the power to hold such an inquiry and court of inquiry has recommended the disciplinary action, then the recommendation of court of inquiry is subject to decision. My lord, it's not bad, my lord. This honorable court also, my lord, that is of Varish Kumar Upadhyay versus Union of India, September 12, 24, coordinate bench of this Gauhati, this honorable. In the judgment, what I have submitted in seriatim, that is in number 5. Varish Kumar Upadhyay versus Union of India, para 16. Coordinate bench of this also speaks the procedural steps and squash the further constitutional. That is in my, that is in serial number 5 of the compendiums of order. Paragraph, my lord, paragraph 16. Gauhati High Court judgment.
In the earlier judgment,
Paragraph 53, my lord. And now, just for a moment, and I have cited another judgment in the matter of decision of memorandum of charges for a issue of no witness, no evidence. But that, as I have earlier read the memorandum of charges, 4861, that is item number 28. And my lord, this, I draw my lord's attention to annexure 4, page 35 for a moment. I bow down. Petition 4861, page 35, annexure 4. My lord, they have cited the documents to prove a charge in the memorandum of charges.
right,
Can the documents come on their own?
we'll continue.
My lord, day after tomorrow, Thursday will be convenient, my lord. Or on Tuesday. But on Thursday, I am deeply grateful to my lord. Acha, my lord, there's one humble submission, my lord. Then they should not, as they have committed on the 5th of February statement before my lord. Can my lord should keep it as a part of matter? I'll be deeply obliged to my lord if my lord keeps it as a part of matter. First,
It is a part of the.
my lord, and next date can be given, my lord, and that is after before, my lord, that is of.
Then it is, then we don't keep it part. Forget it. Otherwise, how do we hear matters?
23rd is okay.
23rd is a missing day. But Mr. Goswami will be there. For your argument, we'll keep it on some of it. Yes. Yes, Mr. Counsel, 24th. What?
Deeply obliged.
24th.
Deeply grateful. Part of matter.
Upper class.
We have kept it for further hearing.
Deputy upper.
First, kindly take 4619. Now, in the year 2017, there was an advertisement. We are Indian Police Organization for the post of Sub-Inspector TD. The year 2017, the present petitioner appeared for the state examination, and in the year 2018, the result was declared. The result, the present petitioner came out successful, and he was selected for the post of Sub-Inspector DD at BSF by appointment order dated 7/2/2019. That is Annexure 1, page 16. Accordingly, the petitioner joined as Sub-Inspector DD at BSF on 25/3/2019. Page 5, para 3. After joining BSF, he underwent training, and thereafter he was posted at 36th Battalion BSF in Indeshwar Nagar, Jammu. While the petitioner was serving as Sub-Inspector GD in Jammu, a notification was issued on 5/5/2022, whereby the Director General issued notification that the BSF personnel were eligible for fill up to the post of Junior Engineer Electrical on deputation. That manner, advertisement was issued that the Junior Engineer were qualified, they may apply for deputation. On 5/5/22, the present petitioner applied for the post of Junior Engineer Electrical on deputation, being qualified, and later on he was appointed as Junior Engineer Electrical by appointment order dated 15/11/22. And accordingly, the petitioner joined as Junior Engineer Electrical at BSF headquarters Silchar on 22/2023. Annexure 4, page 27. That now petitioner has served for more than 3 years as Junior Engineer Electrical on deputation at BSF Silchar. At that time, he was serving more than 3 years, but now it will be more because it was the period at the time of filing the petition. Then, my lord, may kindly see the recruitment rules. That is, my lord, Annexure 13, page 43, kindly see. This is the now 43, kindly see bottom, column 10, bottom, deputation, public absorption. Now below, right side, deputation absorption, serving border security force personnel in the rank of sub-inspector having 3-year diploma in electrical engineering from an institute recognized by the central or state government. So, this was the criteria that they shall be filled up, 60% of the post shall be filled up by direct recruitment, that is page 10 of left side, 43, column 10, 60% by direct recruitment, 40% by promotion, failing which by deputation, absorption. This is very important. Failing which by deputation, absorption. So, here is the serving border security force from personnel in the rank of sub-inspector having 3 years diploma in electrical engineering from an institute recognized by the central or state government. So, they are entitled to get either to absorb the post of 40%. So that is the rules. Now Lordship would say petitioner, so far as 40% promotion is concerned, the respondents for the last 5 years have not filled up. This is very important. 5 years, since last 5 years, the authority did not fill up any post for promotion or absorption since last 5 years, which is compulsory. That I am coming later on. Have not filled up any post of junior engineer electrical by promotion, so therefore they have to fill up the post of junior engineer electrical by deputation absorption as per column 10, page 43. Now there is also an SOP. Can you see the Director General BSF issued an SOP in the year 2013, Annexure 15, page 51. Wherein at paragraph 5 and 8, 5 to 8, it is clearly mentioned that for absorption screening committee will have to be set up twice every year in the month of January and July to assess the suitability of candidates who are eligible for absorption. However, the respondents were not setting up any screening committee to evaluate the performance of eligible candidates appointed on deputation that deserves to be absorbed as junior engineer electrical. Now,
You fall under what?
What
You
is
are-
it?
you
The
are
assess-
the rank of sub-inspector having 3 years diploma.
So I have qualification to be absorbed permanently as junior engineer electrical. Now, Lordship would see the SOP says,
The SOP.
SOP manner, that is manner, page 51.
See?
Says, kindly see operative portion, page 52. Para number 6. A board of officers screening committee constituted separately for officers and ORS will be convened twice in a year in the month of January and July to assess the suitability of deputationists and recommend their cases for absorption as per the eligibility criteria mentioned in the RRs and merits. The composition of the board will be as follows. Now, Lordship, see, the SOP says in the month of January and July, there shall be a meeting for the purpose of assessing the proficiency of the absorptionists who are eligible to get the promotion on permanent basis. So, absorption from the absorptionists. Now, Lordship would say, thereafter, Lordship would say, that was not held. January and July, 6 + 5 years. It's a matter of forces who are dedicating their lives for the countrymen. In the month of January and July, as per their own rules and as per their own SOPs, they shall have to arrange a meeting to select the candidates from the absorptionists. But they did not say 6 + 5 years. So,
What has happened?
then, my lord, we filed a file.
What has happened to the vacancies? Still having
So many vacancies are there. Because 6 + 5 years, nobody has been promoted, either absorbed. Promoted, when not promoted, then absorbed. Now, so many posts are there. Now, when this was the situation, we filed a petition. That Lordship may kindly say, on 31/1, so in view the SOP, we forwarded the petition. Officer forwarded the petition of the present petitioner to the Director General BSF with a prayer for absorption, permanent absorption, but same was returned stating that remarks, recommendation of the Deputy Commandant was required. Lordship would see here. Even on 24/2/25, when I filed application for my absorption, that was forwarded by authority. But here it is said, the Director General returned the said with the stating demands the recommendation of this Deputy Commandant was required. Thereafter, the recommendation of Deputy Commandant was also forwarded. Even then, that was fulfilled. That was fulfilled on 3/4/25, page 31 and 32. So, Deputy Commandant has certified that yes, these persons are eligible and their petition is forwarded. Petition is forwarded for the purpose of permanent absorption. Now, thereafter, when that was said, all on a sudden, first time they said that you bring the recommendation of Deputy Commandant, then we also fulfill that criteria. Then, after recommendation of Deputy Commandant, the application was forwarded. Then the authority said that it is given reference of signal number R325 dated 1/4/25. Here, Lordship would kindly see on 24/2/25, they have said that your petition is returned. You bring the remarks of Deputy Commandant. And accordingly, we fulfill their criteria and file that application. But they said that signal number 4, 3125 dated 1/4/25.
there is a order on our
Yes. 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 In that case also, that was head constable. Head constable he was also in the similar situation, but his case was not considered. Then our High Court passed the order that may be seen page 45. Then, my lord, he was absorbed permanently. Not only he, on the basis of this order, a large number of people who were on persons of the court have been promoted.
Here, Mr.
Now,
We'll come back to you, Mr. Goswami. What is qualified?
What's the next one? The address that some says one of the circular. Pursuant to which one of he applied for the case 19 of the petition.
Yes.
There is no whisper about this that for permanent absorption. It's only a deputation for a period now. The circular pursuant to which they applied for the post one. They are initially working in the post of SI, other the BSN. Within the same organization, there is post of that.
Which particular post are you referring to?
Skill number one, the sub inspector.
This is sub-inspector works. He is, I think, qualified in
Electrical. Next is the electrical for that phase 20. They applied for the there is no whatever they are permanent they know that it's a post for deputation. Since there is a requirement in the department for the electrical.
Twice.
No, then what is this?
About it. Case 40. 40 regarding deputation. Here, serving border security force personnel in the rank of inspector, 3 years. That is not our case. 2 is our case, Roman 2. Serving border security force personnel in the rank of sub-inspector with 5 years regular service in the grade and having 3 years diploma in electrical engineering from an institute recognized by
You are
the
claiming for deputation.
You are sent for deputation. After completion of deputation period,
What to be absorbed?
you will be absorbed because that rules give us that right. That 40% should be by promotion or absorption. Now, since last 5 years, though in a year 2 times they have to select this type of 40% should be filled up by promotion or absorption, but they did not sit. And so we filed petition. Petition on return that bring the recommendation of DC, Deputy Commandant. And Deputy Commandant also gave his remarks regarding our efficiency, our proficiency. And that was in February, 24th February 2025. But later on, they produced one signal that is earlier. But earlier, they did not raise any issue. Kindly see the signal.
Well, are you not going?
We are 40, within 40%. Promotion or absorption? If there is no proper candidate for promotion, our main prayer is that as we are now eligible to get absorbed in renewable engineer electrical,
permanently. So we should be provided that job, but it is, of course, I admit, Honorable Supreme Court has said very judgment that it is not a matter of right, but matter of consideration. It is a legitimate expectation. And there are so many orders. Separate criteria, promotion and absorption, that is to suppose promotions, all posts are filled up. Then there is no scope, but here, 6 + 5 years, no. So many posts are there.
Promotion from which post?
Promotion.
Bigger category.
Earlier we were subjects for GD, but now here electrical engineer, sub-inspector electric in BSF sector. Which the rules provide me that benefit. And SOP also provides that benefit.
Or promotion to some inspector.
Electric. Those persons have qualified. Suppose here, my lord, in respect of head constable GD 10 years, in respect of sub-inspector 5 years.
Now, what is the vacancy position available? It is why this down money for application.
There are several vacancies.
So, in fact, our stand in this, why it is returned back only, without more. And in fact,
Where is the order of returning it back?
is 31, 32 now. Then Annex 7, page 30, return of the application of the permanent also. That engagement in the deputation code. Young that there is a code against it. That is why their application for permanent cannot be considered, Madam. That is why
Where it is stated that there is no.
have any right to continue in the.
Well, they may not have a right, but you have to, there is a vacancy. Ground that.
Absorbed from there is a procedure. There's an extra R3. There's a office of part of. Yes. There is a policy for absorption. But 10 cases, there is no vacancy. Beyond 3 years period, this service cannot be extended now.
Have you stated in your affidavit?
One time. affidavit to say that there is no vacancy. Right. This will be yes about. Can see that this point. Where is the statement in the requirement of services? Where is that ever meant in the affidavit? But that is specifically not there. Then on what basis are you submitting before the court? There is no. Pass an appropriate order. And yes. We are not on that. We are on your rules. Your rules provide three sources of appointment, or rather two sources of appointment. Direct recruit, promote. And in the event promote vacancies are available, then there is a scope for by way of deputation. There is sufficient vacancies qualified based on deputation. File an application for consideration for absorption. Turn it back. Specific remarks or recommendation of DC.
He also gave his
Huh?
in both the cases, he also gave it.
But then why is it saying that?
Then on the basis of so many signal is not the law. Now signal is what kindly see. Signal page 33. From the headquarters, so and so. Lastly, for deputation or absorption at their own, unless is notified by the headquarters BSF request ensure. So it is said that unless it is called for, you will not send. My lord, it is my lord dated 2/4/25. But our case was forwarded much earlier. First, kindly see page 31. Here,
Understand one thing, Mr. Founder. Not a candidate directly to- not a candidate. But trying to present a case saying I'm qualified, I'm on deputation.
this was 5 years.
Please absorb me. That is your case. Now, it's decision to absorb you or not to absorb.
Yeah, that is correct.
Now, if the authority says that unless notified, don't send proposal.
Cannot so because law is not retrospective. It means
It's not about-
retrospective.
It's not about doing retrospective. Allowed a right.
Right? We are not saying
Don't
legitimate
have a right.
expect.
Don't have a right, then what are you here?
Fundamental right, I am not saying that. But legitimate expectation is there. It is almost
Legitimate expectation cannot have a right. You must have a subject for right.
say that around Supreme Court says better to be They have a right to consider their promotion or absorption. That is their. My lord, one thing, my lord, I am reading our High Court earlier order. Can you see? Just 49. Just 49 after 7 lines, prosecution. 7 lines. The petitioners admittedly, having completed the 10 years of service in the required grade only in the year 2016. Here 10 years in the he was a head constable, but I am 7 years. Head constable is item number 32. He is head constable. He has also passed this criteria. Could not be even recommended there. The same was done in the case of those who were considered on 25/14. At the same time, it can be seen that while the petitioner deputation period came to an end on 19/12/16 and 20/12/16 respectively, they had completed 10 years of service in the rank of head constable on 13/4/2006. So, the Honorable Court said that he is qualified. Then, Honorable High Court passed the order, that is para 11. Only short paras. Under the above circumstances, the respondents cannot deny the petitioners for proper consideration for their absorption to the post of sub-inspector, junior engineer, electrical as provided in rules of 2012 by accounting the service rendered by them on deputation as sub-inspector, junior engineer, electrical before their repatriation. In view of the fact that they had already rendered 10 years of service in the grade of head constable as on 13/4/16 and 25/3/16. The result, the respondent number 4 and 5 are directed to place the names of the petitioners before the board of officers steering committee for their absorption, promotion to the post of service inspector, junior engineer electrical within a period of 15 days from the date of receipt of certificate copy of this order. The board of officers selection committee shall thereafter finalize their recommendation as expeditiously as possible, not later than 2 months from the date of receipt of the proposal from the respondent number 4 and 5. So, my lord, our prayer is also same that as both of us qualify, I think 31 and 32. 32 is the head constable.
In the case before the court, right? Was there this earlier considered?
No.
Not considered.
Our
Your
case,
case, it was considered.
our case is also not considered.
No, it was considered and done by on the
So,
ground.
that was on the basis of a signal which was much later. First, our case was recommended. Then they returned and bring the recommendation of deputy governor. Deputy governor again said, then they said on the basis of this signal you can. Then frequently they are changing their minds. But rules and SOPs are same. Yes, that much we want, not more than that, right? That's they have given only reference that if you call, then you find. So that is not they did not apply their mind as regards every January and July they should sit. So let them sit and let them consider my case. If I am ineligible to be absorbed, then
Mr. Roswan, the document relied by the petitioner, that is extra R4 is 104. Affidavit of authorization, and this he also annexed to 2 pages of that standing order. I relied the paragraph 3 and 4 of that document, 104. The standing or supporting procedure, absorption of deputation in the effect. Yeah, read
Paragraph
3.
3.
And therefore,
That's all right, but there are sort of rules where promotion person follow.
Indicated here in this example.
Then there no movie.
I went on to that standing at this stage model. And they have no current right to model for absorption model. No, no,
Right.
Ananda. Paragraph 6 model.
What I notified that his education is kept. Terms of there are certain rules still there. It's not where the promotion quota is not there.
Can you see there?
Mr. Mahmood, that's from the arguments which were required to see. Cloud only. By you see, assuming is not there, follow. Not there.
The criteria for his deputation as to that post. But for deputation to that particular post. But there is no that it doesn't indicate whether he can absorb.
No, it doesn't indicate, but then
But
later on a procedure,
correct.
that assessment of the
They do not have the inherent right. And there is no doubt that they don't have. That's 38, 51. 51 is as well. It's 52. Para 6. Board of Officers Screening Committee constituted separately for officers and ASOS ORS will be convened twice in a year in the months of January and July. We assess the suitability of deputationists and recommend their cases for absorption as per the eligibility criteria mentioned in RRs and merits. The composition of the board will be as follows. So, in January and July, this last 5 years, no sitting have taken. So it is their own policy. And under this rules, while not notification, my learned friends say notification. Notification cannot take away the provisions of rules. Rules will always prevail. In that view, Lordship kindly see page 40. It starts from page 38. Page 40 is the case where it is clearly stated. Page 40 sub Roman 2, serving border security force personnel in the rank of sub-inspector with 5 years regular service in the grade and having 3 years diploma in electrical engineering from an institute recognized by the central or state government, 3 years experience in the engineering setup of border security force, failing which, so that this does not come because we fulfill this criteria. We have, there are more qualification than required. So, Supreme Court judgment in this regard, my lord, I may hear lots of attention. There are 17. In our view, it is true that whether the deputationist should be absorbed in service or not is a policy matter. But at the same time, once the policy is accepted and rules are framed for such absorption, before rejecting the application, there must be justifiable reasons. Rationale number 1 cannot act arbitrarily by picking and choosing, and the deputation is for absorption. The power of absorption, no doubt, is discretionary, but is coupled with the duty not to act arbitrarily or at the whim or caprice of any individual. In the present case, as stated above, so that was held. Then at last the Honorable Supreme Court said, para 18, in this view of the matter, these appeals are allowed. The improved order dated so and so passed by the High Court in civil miscellaneous limited decision number so and so and so is quashed and set aside. The improved order dated so and so relieving the appellant from the post of which he was holding in the UP so and so is quashed and the set aside. Respondent number 1, Nigam is directed to pass order on or before 31/12/1999 absolving the appellant at the appropriate place and from the appropriate date in accordance with the rules. There will be no order as to cost. No, my lord. Here, every pros and cons of this rights or deposition eligibility criteria are discussed and finally held that they should be, they were directed. Here, direct mandamus has been issued because they have fought long time and for fighting long time they had to suffer unnecessarily being the member of the force who are defending the country. So the Honorable Court was also on that view. So our immediate submission lordship will kindly go to the our every necessary document we have annexed. We have annexed our Mr. Begu.
Aspect, my lord, the headquarter DSF has, by a signal, the competent authority has approved that no deputation and no proposal for deputation or absorption will be sent until recommended by the frontier headquarters. Headquarters. The authority has approved that no DSF process not to forward any proposal for deputation or absorption. DSF engineering setup at their own unless it is notified. Right. Directed not to send a proposal. Gentlemen, what your rules say is clearly
Supply particular note,
Citations, but not
but
the
citation we will have to share with each other.
one.
They're disposed of, but we did not supply the judgments to the other side. You should give them an opportunity.
Number 1 last time. Case citations were given, but details were not given. Prepare tomorrow.